So here's continuing the same part of the fresh start order. So we've now finished with the application and appointment of a resolution professional. Then there is an examination of application by the resolution professional. So the RP has got a copy of his application, and within 10 days of his appointment, he shall submit a report to the adjudicating authority on whether the application can be accepted or rejected. Now, what is the key thing? He has to give the reasons for such acceptance or rejection. Additionally, he shall provide the actual details of the qualifying debts and the liabilities eligible for discharge under section 92(3). Now, what are the liabilities eligible for discharge? Interest, penalties relating to that debt from the date of application to the date of the discharge order, because that may not be determinable in the list of qualifying debts, because the debtor may not have even accounted for such interest or penalties or any other sums in relation to the qualifying debt. Both these he has to provide an estimate. Now, during the course of doing this work, which is the review of within 10 days to file an application, file a report to the DRT, he may need some information from the debtor. So the debtor or any other person, which means it can also be the creditor, shall provide this information within 7 days of receipt of the request from the RP. Now, he has received the information, he has internalized the application, understood the application. He has two options before him. He can accept and recommend the case, or he can reject. So at this stage, he does only two things. He accepts the application and recommends to the adjudicating authority, or he will reject in this report. When he accepts, what are the circumstances when he is accepting? 1. The information provided is correct. The information provided should be complete. 3. Obviously, the requirements of section 80 in terms of eligibility should be fulfilled. 4. There should not be any change in circumstances. Okay? And that is when we presume that the debtor is able to, pay his debts. So actually the way the section describes it is, the RP shall presume that the debtor is unable to pay his debts if in his information the information supplied in that context is correct and complete. And second, he has no reason to believe that there is a change in the financial circumstances. So critically, what is the RP evaluating in this application? The inability of the debtor to pay. Then he will reject the application in certain cases. When? Number 1, when I am not fulfilling my eligibility conditions under section 80, or where the information submitted, the debts are not qualifying debts at all. And third is, if the debtor has specifically made a false representation. Now, the resolution professional shall record the reasons for the admission or rejection in his report to the adjudicating authority. So, please remember, RP fundamentally checks whether the debtor is unable to pay his debts. And this is the second part. So, with this we conclude 83. 84. Admission or rejection of application by the adjudicating authority. Once the RP has submitted the report, which is his basic evaluation report of the FSO to the adjudicating authority, the adjudicating authority will either admit or reject the application. So they take the original application, they've got his report now, they will read it together and pass orders either admitting or rejecting. Again, when they are passing the orders, what do they give? They will give you the amounts, qualifying amounts and the amounts eligible for discharge. See, in this circumstance, there is no confusion. Finally, this order is binding on the creditor and the debtor. Now, the copy of this order, which contains the values which are quantified, shall be provided to the creditors within 7 days of the order. It shall be provided to the creditors. Now, in this, there are only 2 dates. Please remember, whenever I am going to DRT will take 14 days time. And within 7 days, they have to serve the copy of the order on the creditor. Now, effect of admission of application. So this is when the real process starts. Till now, from the date of application to the date of this admission, you had an interim moratorium. When the admission is done, the final moratorium, or it's not called the final moratorium, but the moratorium kicks in. And the moratorium is actually a 180-day process which is allowed. Please remember, here there is no extension in the FSO. Whereas in corporate part, there's an extension of that 90 days or 45 days, depending on whether it is normal or fresh start. So, when a moratorium kicks in, now you can get a question on this. What is moratorium? What are all the actions on admission? 1. You have to remember there are actually 8 points here. This is very important. 2 points relate to the same thing under interim moratorium, which is no fresh proceeding or suit, existing proceedings are stayed. There are other 6 different parameters which are variously called as the restrictions on the corporate debtor. What I am not supposed to do. 1. I shall not alienate my assets. So you have 6 points in this particular act in 85 subsection 3. So the 6 points you can put my order because it's one logical way of studying, and I'm not saying this is the only logical way. So my first temptation is to sell an asset. I can't alienate an asset. 2. If I'm proposing to enter into any financial or commercial transaction, then I'll have to obtain prior approval where such value exceeds the value which will be notified by the central government. And since they are using the term central government here, you might get rules for this. 3rd, if I have to keep my business partners informed. 4, I cannot continue as a director or be engaged in the promotion, formation or management of a company. 5, if I am carrying on business in any other name, if I am going to do some activity, financial activity in any other name, and the exact term that they use is disclose the name under which he enters into business transactions, it is different from the name specified in the application under section 84. I have to disclose the name. Okay. And the last is I shall not travel abroad except with the permission of the adjudicating authority. These are your moratorium restrictions. They shall have effect from the date of admission of the application till the conclusion of 180 days. Then we go to section 86. See, now the adjudicating authority, DRT, has sent a mail to, given information to all creditors who were there in the application, saying this is the qualifying debt and this is the liability eligible for discharge. Now, one creditor might say, sir, this is not a qualifying debt. I have security against this debt. So, a creditor may want to express his objection. So, there is a provision in this act for a creditor to express his objection. How does a creditor express his objection? He will not run to DRT first. He has to first go to the RP, give an application to the RP objecting the order or the value stated in the order, and the RP, and how long does he have to do it? Within 10 days of receipt of order, he has to give it to the RP. RP within 10 days has to decide on that particular objection. Now, he can talk about objecting the inclusion of the debt or the incorrectness of the qualifying debts prescribed. Correctness, value, security, whatever. Now, resolution professional shall consider every objection and ensure that within 10 days he gives the decision. Now, and anything which he wants to amend, he can amend at this stage. Now, the section 86(7) is very interesting. 86 subsection 7. It talks about 3 different things for which he goes back to the AA, to DRT. 1, for an amended list of debts he goes back. 2, for orders under section 90, which we will come back to later. So don't get into it now. But he can make an order if this person is not obeying. Okay, and 3, for taking such other steps as he considers necessary. But for this particular section, what is most relevant is 86(7)(a), which means if he is making an amendment, he has to tell the adjudicating authority, he has to prepare an amended list for qualifying debts for the purpose of the discharge order. It's this section that gives him a right to amend what he has previously certified. And it's because everybody does things on an estimate or a best case basis. The last section, 87. Now, the creditor had an objection. RP has resolved the objection, or he believes he has, and he has communicated a decision. But Now the debtor doesn't agree, or even the creditor himself doesn't agree. Then they have a window. So there is a section 87, application against the decision of a resolution professional. Who can prefer the application, the creditor or the debtor? Who should they prefer the application to? They should go to the DRT. Now, what are the grounds on which this application is preferred? You can't say I don't like the RP, so I am preferring an application. No. He has not complied with the provisions of section 86, which is he has to ensure that he has done it within 10 days. He has considered each and every objection. 2. If the debtor or the creditor feel he has colluded with the party, colluded with the debtor. The third option is if they feel he has not given the creditor a reasonable opportunity of being heard. Please remember, under 86, only a creditor will file an objection to the RP, because debtor has already told his side of the story before RP has admitted the application. Now, under section 87, debtor or creditor can apply to the DRT against the decision of the resolution professional. Again, this has to be made within 10 days on these 3 grounds. And okay, third is the sorry, I'm very sorry, just got a bit distracted. So these 3 conditions are fulfilled, and please remember, whenever something has to be decided by DRT, it is not 10 days, it's 14 days. DRT will prepare its final decision. Okay, so with this we conclude here, which is 87. Now, if any orders are passed in 87 because of the fault of the RP, then they will keep the board intimated for initiating any process against the RP. This is very important. Okay, so this is still section 87. Thank you.